Welcome to the Cheeley Law Review. My name is Ben Burnett, and my guest today is Bob Cheeley. Bob, how are you?
I'm fantastic. How are you?
I'm doing very well. Bob, today I want to talk to you about medical malpractice. What is it?
Medical malpractice can involve any combination of doctors or hospitals or medical providers who fail to provide medical services that comply with what is called the standard of care. In our country, we're blessed to have really high quality doctors and nurses and hospitals as a general rule. But statistically, more people die due to medical negligence every year than I think die on highway crashes on the interstate highway system. So it's a significant issue, and it comes down to basically finding a good attorney who knows how to evaluate the case and pursue it to a successful conclusion. But they're difficult cases as a general rule.
When you say that there are difficult cases, is that because the standard of care is not an absolute from a definition standpoint, or is it because that hospital systems are unbelievably overlawyered and overinsured and are designed to make it harder on average people being able to pursue what may be justice?
As a general rule, standard of care in different areas of medical practice, there's a consensus as to what constitutes good care and what constitutes subpar care. But there are gray areas. That's kind of where medical judgment can come into play when a doctor is called upon to look at maybe taking out a part of the body, maybe as suspicious for a tumor, and winds up cutting into something else. And that can be from not taking necessary precautions like MRIs ahead of time, but it can also be I did my best and I still had a bad outcome. So generally speaking, there are principles of standard of care, but there's also known risk that orbit around the standard of care. Doctors are generally recognized to not be responsible for if there's a bad outcome, if there's situations that are beyond their control.
Do you see it more common in certain types of medicine than others?
I don't know that it's more common in certain areas, but I would say, broadly speaking, there's a lot of cases that get filed where there's a failure to diagnose. Maybe there's inadequate MRIs or X-rays or CT scans. Had they read them correctly, they would have seen a condition that should have been attended to earlier and that could have led to a successful outcome, but instead led to cancer because it wasn't properly diagnosed.
I know that this is an avenue that you have explored with your firm. I won't say later in your career, respect to your age, but I know it was not what you started out pursuing from a vocation standpoint, but I know that it is something that you have become more familiar with in the last few years. Tell me from a legal standpoint what it is that you have learned about that business that separates your firm and your ability to continue learning.
When I got out of law school in 1982, I went in with my father, and he had been practicing in Beaufort since the early 1950s. And he had some cases that were, medical negligence cases. And I remember the first one that I worked on was for a delightful lady who went into the hospital. This was a nursing negligence case, and this is a lady who was wheelchair bound, and they tried to get her up out of the bed without a bed lift, person lift. One person tried to hold her up, and she couldn't, and she sank to the floor. Miss Liddell was her name, my client's name, and it broke both of her femurs. And they, instead of calling a doctor and reporting it, they put her back in the bed. And so she was being turned and daily, and those broken bones in her thighs were cutting into the muscle and the surrounding blood vessels, and she bled to death. So I took that case to trial in like 3 years out of law school. So that was probably my first opportunity to try a medical malpractice case. And I won it. It was over the last 40 years, I probably can count on two hands the number of times that I've actually taken a case and ran with it on behalf of a client, because they're just 98% of the ones that you look at, they don't have the right ingredients. There's three things you got to prove: breach of standard of care, you got to prove causation, and you got to prove permanent injury and damages. Inevitably, where the cases are fought by the lawyers defending hospitals and doctors is on the first two grounds: the breach of standard of care. They'll contend there was no breach of the standard of care, and they'll call in experts to say as much. And they'll also fight you on causation. Typically, they don't fight you on damages. I'd also add that I get a lot of satisfaction out of the cases that I do take for people and get justice for them, because a lot of times these people have just been run over by the system. But it's a big boy game, and if you're going to play on that field, you better buckle your chin strap and prepare to spend a lot of time and a lot of money to get your client's case to a point where it can be either settled or tried.
This has been another episode of the Cheeley Law Review. Have a great day, everybody.